Prof, thank you very much for making time to join us this morning. I know it's, what time will it be where you are? Hello, Prof. Please unmute your mic. Hello, Prof.Asare.
Good morning, Samson. Sorry about the glitch. I think I'm unmuted now.
That's all right. So what time is it where you are?
Good question. I think it's about 4 o'clock, maybe 5.
We put you through this all the time. Thank you very much for your commitment to this country.
Thanks for having me. I enjoy being with you on the program, and I enjoy exchanging ideas.
Right. So now tell us, what is the wisdom that went into the prohibition of dual citizens holding certain offices in this country? And what is the new wisdom that is now leading to the possible removal of all those, prohibitions?
You mentioned that there's a bill in Parliament already. The bill has gone through gazetting. It's been published twice in the Gazette as required by the Constitution. It's been introduced into Parliament, and consistent with the Constitution, it's been referred to the Council of State. The Council of State has given its advice. And so the next stage is the second reading, followed by the third reading. At each reading, there's a vote, and for the bills to pass or for the repeal of the articles that we want to repeal to pass, we need about 183 votes. I believe that is a significant piece of legislation that is in Parliament for a variety of reasons, because of the substantive things that it seeks to do, but also because of the process. It's, my knowledge, the first time that a private member's bill is being used to amend the Constitution, and the bipartisanship surrounding the process has been beautiful. The Speaker is to be commended for his leadership. The majority and minority sides are to be commended for their bipartisan approach to this. The Council of State has evaluated the bill and in its wisdom has given the advice. I heard President Mahama giving his support for the bill. And of course, in July 2019, the current president also indicated that he supports such a bill, Samson. Now, when you spoke, you talked about Article 8.2, but you didn't mention Article 94.2a, which is actually the bigger problem. And I don't know whether you are seeing my screen, Samson.
Yes, we can see. So go ahead.
There are currently 4 laws enabled by 3 distinct sources of power that provide 2 distinct bases of public office holding exclusions. And it's important that we separate them. We have the constitutional burdens, which is Article 94.2a, and that is, as I say, pursuant to constituent power, and that is not about dual citizenship, that is allegiance-based. And then we have Article 8.2, which is pursuant to constituted power, and that is dual citizenship-based. The important point there is it is due to constituted power. That basically means it is an amendment. It is an amendment of the original Constitution compared to constituent power, which means Article 94.2a was always in the Constitution, and Article 8.2 is what I call the First Amendment. In Ghana, our First Amendment is Article 8 that deals with dual citizenship, because prior to the amendment, dual citizenship was not even allowed. And so Article 8.2 reviewed the arguments for outlawing dual citizenship and said, no, look, these arguments do not hold water. let us amend the Constitution and let us allow dual citizenship. And then we have the statutory burdens, which is Section 16.2 of the Citizenship Act, and then Section 13.1a of the Office of Special Prosecutor Act. Section 16.2 is dual citizenship based, and Section 13.1a is allegiance based. Now, what is the effect of each of these laws? One, Article 94.2a, it is very deceptive when you read Article 94.2a because it talks about a person who owes allegiance to a country other than Ghana is not qualified to be an MP. That is a very important provision because qualification to be an MP is central to representative government and is central to citizenship. A person who is not qualified to be an MP is also not qualified to be many things. One of them would be the Speaker of Parliament, and then that person is also not qualified to be on the executive. So, for instance, they cannot be president and vice president. They cannot be ministers of state, deputy ministers, and cabinet. They cannot be members of the constitutional bodies, including the Electoral Commission, the Public Service Commission, the NCCE, the Lands Commission, and then the Regional Lands Commission. So it's very important. And then lastly, if you are disqualified from being an MP, then technically you cannot be a founding member of a political party, you cannot be an executive member of a political party, and you cannot be a leader of a political party. So if we enforce Article 94.2a the way we enforce it when people are seeking to enter Parliament, which I argue is a wrong thing, then even if you take the diaspora branches of the various political parties, dual citizens are not supposed to be executive members under Article 55.8. Then there is Article A2. Article A2 is straightforward. It is about dual citizens. It says that a person who is a dual citizen cannot be the following offices that are enumerated here and which you read out as well. No need to belabor the point. Then we have Section 16.2. Remember, if you go back to Article A2, when the Constitution was amended, this is the First Amendment. Under the First Amendment, there's a stipulation that Parliament can add any office to the list of positions that dual citizens cannot hold.
That's
and
right.
Pursuant to that power, Parliament passed Section 16.2 of the Citizenship Act and added the following offices, which you have read and which I'm not going to go over again. And finally, the Office of Special Prosecutor Act, Parliament also added that a person who owes allegiance to a country other than Ghana cannot be a special prosecutor. So we need to make sure that we understand that we are talking about either dual citizenship or allegiance. And in my opinion, the two things cannot mean the same thing because in law, as you know, there's what we call the principle of meaningful variation or the principle of consistent usage.
All right.
And that basically means if you say dual citizen, it means dual citizen, but then if you use another term, that term cannot also then be construed as meaning dual citizen. Now, let's look at the reasons that people normally give for why dual citizens should not hold office. First, they say that they have divided loyalties. Second, they say that they will be confused or conflicted when it comes to war or diplomacy or extinguishing fire and so on and so forth. See, for instance, the case that I sent to court in 2012. They say they can chop money and run away to their other country. They say they want to eat their cake and have it. They say they will compete unfairly against politicians. They say they will take jobs away from mono citizens. They say they are not full Ghanaians. And they say you cannot serve two masters. Something, if you look at the list, you will see that this is an old and discredited argument because the same arguments that I recited were the arguments that were used in the first place to outlaw dual citizenship in the 1992 Constitution. However, Parliament revisited this problem and said, look, these reasons do not hold water, and therefore let us amend the Constitution and allow people to hold other citizenship. So basically, these are arguments that have been rehashed and that were sometimes previously rejected. Second, experience has disconfirmed the fears. Why do I say that? Well, because since 1996, when we passed the First Amendment, we've been waiting for these things that dual citizens are supposed to do, and nothing has happened. We haven't seen any dual citizen betray the country. We haven't seen any dual citizen eat his cake and have it. We haven't seen any dual citizen serving two masters, and so on and so forth. So we've had a natural experiment, and we have longitudinal data from 1996 to now to show that these fears are not just hypothetical, but they indeed have not materialized. Third, there's this question of divided loyalties. Something, when you look at the list that we looked at and the positions that dual citizens have been excluded from, it's hard to understand how divided loyalties apply to many of the positions. For instance, are we arguing that the special prosecutor will not be able to go after corrupt people because of their shared citizenship of a foreign country? The reality, Samson, is that most professionals have different loyalties, including to tribe, including to religion, and so on and so forth, but can discharge their professional obligation without allowing these allegiances to get in their way. In fact, this is the argument that people use when somebody with political affiliation is appointed to go and serve on the Electoral Commission. They argue that, well, merely because the person has a political affiliation and merely because the person votes doesn't mean he cannot be a professional and he cannot discharge his duties with professionalism. With respect, the same arguments hold here. And then another important point is that there is actually data on this. Somebody actually studied this with Swiss nationals and found out that all the fears about divided loyalties really hold no water whatsoever. Then they talk about the person can misappropriate funds and run away. Well, this argument understates the country's ability to use the mutual legal assistance framework to go after criminals. Let's note that foreigners in Ghana are not even free to come here to commit crimes and run for shelter in their countries, because we can go after them, and therefore we can go after someone who is a Ghanaian and who absconds with our money. There are ways to go after that. In any event, if that were the case, the obvious solution is not an extreme ban on everyone, which becomes overbroad, but rather we need to place misappropriation controls so that people are not actually misappropriating funds. Then there's the cake argument. That one is one that I don't understand, because it almost assumes that people go to public office to eat some cake, and therefore they don't want other people to come and eat that cake and then somehow have it. I don't understand that argument. What we are talking about is public service, not eating cake. And so this argument I don't find credible. Then there's the fair competition argument. The fair competition argument also lacks merit, because it is the appointer, the person who is making the appointment, it is the voter who would have the decision right to hire citizens for public office. A dual citizen cannot force himself on anyone. And then some people say, well, dual citizens, they are fractional citizens. They are half-baked Ghanaians. There's no such thing as a fractional citizen. If you are Ghanaian, you are Ghanaian. It doesn't matter that you are a citizen of another country. You are 100% Ghanaian, and you are 100% a citizen of that other country. Remember that Ghanaian citizens have the same duties under the Constitution. The Constitution does not say that if you are mono Ghanaian, you have more responsibilities or higher duties than someone who is a dual citizen. So we must treat all our citizens equally. And then there's this notion of serving two masters. And again, that is a problematic view of the problem because citizenship should not be viewed as a master-servant relationship. It's more about a reciprocal rights and duties to the state. These Ghanaians, when appointed or elected, will not be serving two masters because they must relocate and reside in Ghana before their nomination or appointment, and they will be serving only in Ghana. They will be serving only in Ghana, and they'll be serving as professionals with professional obligations. They will take oath of office, and they will be bound by their oath of office. Now, another variant of the serving the two masters argument is posited in 1815 by the US Secretary of State, George Bancroft. He noted that nations should as soon tolerate a man with two wives as a man with two countries, as soon bear with polygamy as that state of double allegiance. Well, this view of polygamy and double allegiance is not one that is accepted by all cultures. In fact, in our culture, polygamy is allowed by some sectors. And my better analogy is that one's allegiance to a wife does not diminish their allegiance to their mother. Now, in any event, you can see that all these reasons and arguments that I'm putting forward are entirely speculative and are not based on any empirical reality. Similar hypothetical and speculative concerns may be raised to disqualify just about everyone from holding any position. So, for instance, you can easily say, well, if a person is poor, he should not be given public office because his poverty might compel him to steal. But disqualification should be based on real actions, such as conviction for crime, rather than mere suspicion that one may act in some unspecified, undesirable way merely because of their status, proclaim that, and then enact that into law by penalizing them even before they've done the thing that you said they could do. Now, so we have debunked all the arguments that they put forth about why dual citizens should not hold office. Now, let me give you my reasons why I think dual citizens should be allowed to hold public office. My first ground is economics. Ghana is a net exporter of skilled labor, and we have to be aware of that. And we have to have return-friendly policies that attract these skilled labor and their wealth back to the country. A repeal of the law that is allowing people who are dual citizens to hold public office would encourage and stabilize both remittances and return migration. Furthermore, it will facilitate the use of vehicles such as the diaspora bond, which countries like Nigeria and Israel have put to good effect. But the reason they've put to good effect is they've not categorized their dual citizens as disloyal. They have embraced them. And by embracing them, it's much easier to then go to them and say, well, come and invest in the country, buy diaspora bonds, and so on and so forth. Second, I have Republican grounds as a justification for the repeal. Under that, I know that the right to fully participate in the public space is the asset test of citizenship. If you can't do certain things, then you shouldn't be called a citizen. So, for instance, what is the difference between a citizen and an alien? Well, a citizen can vote, an alien cannot vote. A citizen can sit in parliament, an alien cannot sit in parliament. A citizen can be part of the executive, an alien cannot be. If you have a citizen and the citizen cannot do all those things that we enumerated, then what you have created is not really a citizen, you've created a fractional citizen. It's not dual citizen, it's a fractional citizen. Second, it aligns with our constitutional duties. I've already explained that because that duty is imposed on all citizens, not some citizens. Third, it avoids a situation where we have classes of citizens, some with supra rights and others with sub rights. We need all our citizens to have equal rights, have one vote, allowed to be voted for, and so on. Third, there's a public interest argument, and ex-President Mahama mentioned this in his interview the other time. We have our brain trust all over the world, and we should be able to tap into that brain trust, similar to the way we select our black stars. We don't ask whether you are a dual citizen or not. We ask, are you a Ghanaian? And if you are a Ghanaian and you are very good at playing soccer, we put you in the black stars. Kevin Boateng, he goes and he performs, and we are all happy. We are not worried that if there's a penalty and Kevin Boateng has to play it against Germany, somehow because he's also a German, he's going to somehow kick the ball to throw. No. When you wear the jersey, you are a professional. You are a professional, and you will do your job accordingly. I also know that most of the excluded positions are technocratic and should be based on skills, knowledge, education, experience, and training, or what I call STEET over here. We need meritocracy, not some ambiguous loyalty that nobody can define and nobody can tell you what it is. And I've already noted that professionalism trumps primitive allegiance. So I'm an attorney. If a client who is not a Ghanaian hires me to go and sue the government of Ghana, I'm not going to say, well, I'm a Ghanaian and therefore I'm not going to do my professional work. No professional thinks that way. You are hired to do a job, and you are able to set aside your allegiance to your family, your allegiance to your tribe, your allegiance to your religion, your allegiance to your country, and do a professional job. That is why, Samson, Ghanaians, Supreme Court justice and other justices are able to go to other countries to sit on their Supreme Court and sometimes to even serve as the Chief Justice of those countries. So both in Gambia and in Kenya, we've had Ghanaian justices who actually went to their courts and presided as Chief Justice. Presently, they were not worried because this is a technocratic position, Prof, and they have confidence.
Prof, it's not only a matter of the past. As we speak, there are Ghanaian judges who are both judges in the courts in Ghana and in the Gambia.
Precisely. And yet, in our own country, a Ghanaian who just happened to also have the citizenship of another country cannot sit on our Supreme Court. And this actually discourages people, some of the people who have dual citizenship, some of the judges who have dual citizenship. They don't aspire to go to the Supreme Court because they don't want to trade their other citizenship to sit on the Supreme Court. So we are hurting ourselves. Sometimes the president wants to appoint somebody, but he can't appoint that person because of that law. Now, I've also mentioned that professionalism trumps primitive allegiance. And then the last point under the public interest is that the repeal of the law will arrest a potentially explosive exclusionary tool. And what do I mean by that? Look, if we look to our neighbors to the west, that is Cote d'Ivoire, they had a civil war. The first civil war was triggered because of this citizenship issue. Alassane Ouattara was being disqualified from holding the office of president because allegedly his father came from Burkina Faso. And that was enough to cause that first civil war. There are examples of that all over Africa. And I cite an example of somebody like Kenneth Kaunda, who basically was the founder of Zambia. But in 1996, they wanted to disqualify him from public office because allegedly his mom was from Malawi. Why are we doing this to ourselves? Why can't we take advantage of all our skills and put it to our use? Fourth, I think we need to move beyond rhetorics in this area. Repealing the law aligns our public office holding policies with our rhetoric on the diaspora. We always have the Joseph Project, the year of the return, and so on. And when we do this, we even give some foreigners citizenship. Now, what are we telling the foreigners? That we are giving you citizenship and thereby making you a dual citizen. And in so doing, we are making you disloyal to Ghana and your other country. Why would we, on one hand, say that dual citizens are disloyal and yet happily confer citizenship on foreigners so that they become dual citizens and we exclude them from our political space? But if there are other countries who are thinking like us, then they would also be excluded from their political space. Fortunately, most countries do not think that way. I also mentioned that the repeal will fulfill our obligations under the Africa Charter and will realize the constitutional promise of equal citizenships. And then finally, I mentioned that it restores the presumption of loyalty and innocence by refraining from penalizing based on suspicions and speculations. It also puts us in tandem with the rest of the world. Sierra Leone, UK, Nigeria, Canada, USA, Senegal. These are examples of countries that allow their dual citizens to hold any office. In fact, Samson, if you look at a country like UK, you don't even have to be a citizen of UK to sit in parliament. If you are a resident and you are a citizen of a Commonwealth country like Ghana, you can sit in their parliament. That is progressive. That is progressive. And I would argue later that Article 94(2)(a) is language that the British exported to all their colonies. So if you do a comparative review of constitutions, every Commonwealth country has this allegiance clause.
All right.
Ghana is the only country that interprets it as dual citizenship. Okay. And then we talked about the exclusions, distraction from our liberal credentials. But let me make 2 quick points. First, this law, when it's repealed, does not entitle anybody to a job. It just restores their right to participate fully in the public space. Voters still will control who should represent them, and then the appointers still will decide who should be appointed. When to exclude? Are there any circumstances under which somebody should be excluded from holding public office? I believe so. I believe so. But I would say this should be limited to situations where there are compelling, specific, articulable interest, not speculative interest.
All right.
And in any event, these restrictions must be narrowly tailored. And I would argue argue that we should apply a conflict of interest framework where there is risk. That means you disclose or you exclude yourself from certain decisions if there is the potential that your other citizenship will be in conflict with your job that you are doing. But a blanket ban is too broad in my mind. Let me cite 2 Ghanaians, and then I'll start up. First is Prof.Asare in 1968, when the same issue was being discussed. Here's what he said. I've heard the argument that if somebody who is what they refer to as half Ghanaian becomes president, he may owe allegiance to another country. Well, that may be so, but this is a matter which should be known to the Ghanaian electorate. And if the Ghanaian electorate choose to elect such a person, that's their business. I think this is an issue which should be left to the Ghanaian electorate, and that all Ghanaian citizens should be given equal rights. Prof.Asare, 1968. I totally agree with that. And last, Kufuor basically says, now there are a lot of intermarriages among the races. And if a person comes to Ghana and marries a Ghanaian woman, if their children were made to suffer because of this intermarriage, then I do not see any justice in this. Therefore, if you are going to discourage people because of birth and preclude them from occupying high positions in our society, it will not be in conformity with civilization and natural justice. Thanks, Samson.
Thank you very much. Excellent. And that is detailed and brilliant.